That is me, Danny Bonaducci, life coach, with special guest judge, Rick Jones. Give us a call right now, 1-800-252-1025.
All right, let's start with some calls. Eric in Tacoma was the first person through. Eric, good morning. You're on with the life coach and Rick Jones.
Good morning, Rick Jones and Sunshine.
Good morning, Sunshine.
I got a question. Me and the wife are splitting up, and we're not exactly ready to do the divorce part of it, but she doesn't handle her finances very well. If I get a legal separation, will that protect my credit score, I guess?
Well, the easy answer is yes for anything going forward. The problem, and what a lot of people don't realize, is that a legal separation isn't a simple process. You would still have to divide up assets and liabilities and deal with all other issues in a permanent way that you would have to do in a divorce. So it's usually not an easy answer.
So it's everything a divorce could be without having to get the divorce. There's nothing special about well, there is something special about it, but you've done all the hard labor you have to do to get a divorce. You just haven't signed any dotted lines to say we're single now.
That's right. At the end of the day, you're still married.
So, but would you recommend for, even though it's a lot of work, if he wants to protect his assets, should he file for a legal separation?
Well, the assets that exist already, there's no protection for. The real key to him is going forward,
right?
And whether he needs, for example, whether he plans on making any purchases going forward or getting into any debt going forward, that certainly would separate it out. So that's really the only reason. Again, my recommendation is that it's a lot more complex than he's giving credit to.
Wow. Okay, make sure to check into that before you do anything silly, or if you're going to do anything at all, then I'd call 1-800-DIVORCE. Thanks for the call.
Up next is Rick in Tacoma.
Hey, Rick.
Good morning, Rick, Danny, and Sarah. How you guys doing this morning?
We're good, thanks.
Hey, this is a question for Rick. My son's 18, getting ready to go to college. Both myself and my ex have degrees. Wondering if I'm required to pay for his college half or any of it. I plan on giving him $10,000, but that's about all I can manage.
Do you have a support order already in place?
For college?
No, just in general, a child support order?
Yes.
Okay.
We've been divorced for 8 years.
Okay. Was it in Washington?
Correct.
Okay. There should be a section in there called post-secondary support that speaks directly to whether you have an obligation or not. Do you recall anything like that?
At the time, I thought I was wrong with everything, so I just signed away.
Okay. Well, here's what's probably the case. And I'm playing a numbers game here, but the vast majority have language that says the issue of post-secondary support is reserved and that either party can raise the issue prior to the termination of child support. Now, is your 18-year-old already graduated, or is he in his senior year?
He's in his senior year.
Okay. What that really means, if it's as I say, then either of you, whether it's you or your ex, can raise the issue prior to the termination of this support order, which is really looked at as through the month of June, which is the month of his graduation.
And remember, you can read him all the stories that have come out in all the magazines and show him the news things that say, is a college education truly worth it? And I'm not saying that to be funny, but there are people who really agree now with college loans and things like that a college education is not worth it. I'm not one of those people, but, are you sure he's going to go into college?
Yeah, he is. He's going to be a nurse, so he's pretty directed in that way.
Well, good for him. And like Rick said, I have that in my divorce decree and absolutely didn't know it. I thought, here's the money they asked me to pay, and I'm going to pay it every day, every month on time. And then it turns out I dodged a bullet on Isabella, but it turns out that if Dante goes to college, I'm paying a certain percentage of that, and I didn't see that coming. So read your divorce decree. And thank you. And good job on calling when Rick Jones is here.
Rick Jones from 1-800-DIVORCE. Goldberg Jones is here with all of your questions, and it's, of course, Danny Bonaducci, life coach. Dave in Federal Way, you're on.
Yeah, so I got a few questions, I guess. One is my kid's mother moved away, and I got custody of them. So the parenting plan says that she gets them for the entire summer. But she has since moved back to this state, and I was wondering why it is so difficult to get the parenting plan modified so the summer visitation is equal. And then my other question is, I've had custody of them for probably like 7 years. So what, pretty much every time they go over there, she just constantly tries to undermine, everything that I do. And I'm like 100% positive that if I march her into court to try to modify that, she's going to try telling them, oh, well, they should live with me. They want to live with
I promise you 100% that's what's going to happen.
Oh, I know that's what's going to happen.
Not to wrap you up in a big hurry, but do you have a specific question for me or Rick Jones?
Yeah, why is it so difficult to get the parenting plan modified to get the visitation changed, and what are the odds that she would win that argument?
Sure. Well, in terms of it being difficult to ever modify a parenting plan in a significant way, like you're talking about, that's just part of the rules of modification. There's a higher standard. The reality is the courts don't want people lining up to try and change a parenting plan over and over. But in your case, it may not be that difficult. I'm assuming she got all summer long because of it being a long-distance parenting plan. And my guess is she probably doesn't have then an every other weekend schedule in there, because if she had moved away, that wasn't even possible. Is that correct? Okay. So apparently you're giving her extra time that's not in the parenting plan during the rest of the school year, correct?
Yep.
Okay. Well, see, now what should happen is she should be agreeing to a modification, because what doesn't work for her is not having specific time during the school year. What doesn't work for you is this huge chunk of time during the summer. So perhaps what you're willing to do is to create an agreed parenting plan that reflects now it's a local relationship. So she has more frequent recognized visitation, but less time during the summer.
Oh, good luck, and thank you very much. And thank you, Rick Jones. And by the way, real quick, God, you're good, Rick. That's the agreement I have in my divorce. I took care in Southern California. We lived 3 blocks from each other. And then literally within 2 weeks, I moved to Philadelphia, and I've got every other weekend and Wednesdays. Mm-hmm. And it's useless to me. And I asked an attorney, not as great as you, what should I do here? And he said, they're really going to hate to modify anything where you get summers. It'd be a big fight. And I called on it. It was a big fight. And you, sir, give great advice. You could have been my lawyer on that one without even being in the room.
I would have loved to help.
Thank you.
Steve in Seattle, you're on with Danny Bonaducci, life coach, and Rick Jones.
Good morning.
Morning.
So I have a 14-year-old son who his mom and I have been separated or divorced for 12 years. We've had a parenting plan in place that entire time. It's never been modified. Now at 14, he's come to me and told me that he wants to be with me. He wants to live with me and my family. And I'm not sure how to approach that. Will the courts take his opinion, his desires into account? Can I just go in and simply file a modification and have him placed with me when he's not in any danger or any concern with his mom? He's just decided that now at 14 he'd rather be with his dad.
Well, in general, I've got bad news for you, which is simply desiring to switch custody is not going to be enough, and the courts are going to be extremely reluctant, if at all, to consider any sort of desire or wishes on your son's part. The key whenever you're trying to modify something like this, again, we talked earlier this morning about being a much higher standard, is you have to show that there's been some sort of substantial change in circumstance that's resulting in existing harm to the child. And the harm part's difficult. Usually it's going to require some sort of third-party corroboration, like a counselor, stemming from school issues, absenteeism, things like that, to even have a chance at getting your foot in the door.
So your answer is basically no, but I just want to know, a 14-year-old who has gone through puberty can't make the decision, I'd rather live with my dad, and the court won't hear it and care that much.
The day they get to decide is at 18.
Wow, really interesting.
Yeah, we did have one more person waiting. Let's put you guys on quickly with Tony and Olympia.
I'm here.
Hey, what's up, Tony?
Hey, just a quick question. It's similar to the one a few calls ago. I've been divorced for several years now, happily paying child support to support my daughter. Now, a couple of years ago, my ex took me back to court to increase the support, and I was privy to see her financial records, and she's very deep in debt. So the judge increased the child support. Now, my daughter's going to be turning 18 here in a few months. What is the possibility of my ex hitting me with continued child support for my daughter's post-education?
Sure. Well, and it probably applies already, not just to 18, but finishes high school. Is she a senior this year?
she is a senior this year.
Okay, so let's start with the fact that you're likely to have this liability for child support through the month of June 2014. So you've got another 10 months still to go. But in terms of the likelihood of her bringing this, you know that better than I do. I don't know what her makeup is. I don't know if she's going to be expecting you to provide support. The silver lining, if she does, is that becomes an obligation that both of you have. Right now it's just you writing the check to her, and it is child support, and it's frustrating because you don't know where it goes to. The pride you can take when you pay post-secondary educational support is oftentimes you're able to pay directly to the school, to the institution, and it's going to be a percentage base. Whatever percentage you have, she's going to have some similar percentage that she has to pay as well.
All right, that is all the time we have for Danny Bonaduce, Life Coach. I'd really like to thank Rick Jones from Goldberg Jones. Feel free, it's Divorce for Men. Feel free to call 1-800-DIVORCE.